All right. I'm going to ask you to have a seat in the audience while I contemplate this for a minute. I'm going to do some other cases, two things at once, to announce to the women of the community that they found a man that can do two things at once. Because I'm going to consider, yes, thank you. I'm going to consider this argument and then do some other cases at the same time. Hang on, I'm getting to the end. My Roman numerals aren't that good. Like 50 category B felonies for child abuse and neglect. And so normally, of course, to take all those 40 or 50 category B felonies for abuse or neglect and then say we want to plead them down to 2 misdemeanors or 2 gross misdemeanors would normally shock the conscience of the community and the court.
Right.
So I need to hear from you and the district attorney's office why the DA wants to plead this down to 2 gross misdemeanors. John?
Your Honor, this case predated me, and if you see the complaint, it alleges several different versions of how the abuse was, whether it was physical, whether it was the water they were drinking, and basically all these kids, the only reason there's 45 counts or whatever is that because there was 45 kids there.
I think 45 kids makes it worse than if there was 1 kid with 45
And
kids.
there was no like specific damage or anything. It was just basically this case shut the place down, and that's the best thing that happened.
The first one is potable water and tap water. The second one's the same. Third one's the same. So is that what this case is all about? Is that there were 40 kids at this facility and they didn't have good drinking water?
They did have good drinking water. My clients were working through, with the Attorney General's office, trying to get their water situation taken care of. And while they were working with the AG's office, okay, and everything was fine there on a civil matter, there were a handful of deputies here in Nye County that took it upon themselves to make this the biggest case that come out of Amargosa in 30 years. And it shouldn't have never happened. This was a situation that was really being taken care of by the AGs. But
Let me ask you with more specificity. I'm glancing at the different counts and they all seem to be similar, although I'm only about halfway through the 40 or 50 counts. And it says that they caused the child to suffer physical pain or mental abuse by failing to provide said child with sufficient potable water and by failing to ensure that the child was not able to ingest unsafe tap water, or by failing to adequately screen and supervise the faculty and or staff to protect said child from physical pain and or mental suffering inflicted by the staff via physical and or verbal abuse. So far, looking through the counts, I haven't seen any elements of physical or mental abuse.
you're right, and that's
Are
part.
there any?
No,
It's all just drinking water?
correct. And on top of that, the drinking water, my clients were giving the children drinking water. All they had to do was ask, and apparently the story got to the sheriff's office that they couldn't get water every time they asked. And that's what just started this whole thing.
Why did the state put the elements of physical and verbal abuse in the counts if there were no physical?
That was the original you're talking about, right?
Right.
Yeah, you got me.
All right, John, I'm about on 30 so far. Is there anything you want to add regarding what the state's thought processes were on pleading these 50
No,
counts down to
I know
one?
at some point there were some allegations that some of the kids made. All of the kids there had some kind of mental issues. That's why they're there. But none of them led to specific charges. I mean, like I said, you can look at the complaint. It's kind of, they did this or they did this or they did this. And the only one that could really stick, we thought, was the water. And again, that's a separate issue. But
So after talking to all your witnesses, alleged victims, and the staff, and the totality of the facts and circumstances, your office made the determination that the only legitimate complaint was potable water, drinking water.
And the reason for that partially is so we didn't have to use the kids. As you can see, they're not named in the complaints, they're just initials. So as far as we know, these kids are in the wind.
Do you have any victims here today that would like to testify?
No, Your Honor.
Has your office attempted to locate the victims?
Based on the timing of this, Your Honor, I don't believe so. The allegations happened in February of 2019.
All right, as you know, I don't now do, and never have done social media. Fortunately, I have 20-year-old and teenage kids at home that can turn on my phone and computer for me and so forth, but I don't do social media, and I haven't really followed this case at all in the papers. It's in front of me right now for the first time. It was in Judge Walker's court, and for some reason it was transferred to me, so I'm unfamiliar with it. I'm looking at the information, and there's like 50 counts with 50 different kids using their initials for category B, child abuse or neglect. The state's appearing in front of me today saying they want to plead it down to 2 gross misdemeanors. Let me take a look at the amended information. Conspiracy to commit child abuse and neglect, a gross misdemeanor, for crimes committed between February 8th and February of 2018 and February 12th of 2019 at the Northwest Academy at Armagosa. And it says by failing to provide the children with potable water and making sure they were able to ingest unsafe tap water, by failing to adequately screen and supervise the faculty or staff, and failing to protect the child from physical pain and or mental suffering inflicted by said faculty and or staff via physical and or verbal abuse. Now, that makes me nervous, because she comes in today, I say, okay, plead to 2 gross misdemeanors. Do you want me to give her a fine and send her on the way? And then next week I read on the front page of the Review Journal or something, woman who let her staff beat kids with whips all the time gets to plead to 2 gross misdemeanors for drinking water, and it makes me nervous.
Well, then I would obviously do myself would provide the local paper or whatever, a counter position.
I'm not concerned about the paper, of course. I'm so well loved in our community that I'd be reelected anyway. I'm not concerned about the paper. I'm concerned about the injustice of the state knows that 50 kids were beaten and abused and so forth, and it went on for a long time, and now we're pleading them out to 2 gross misdemeanors. That would be an
Except
injustice.
there's no evidence of that. It was the
Well, that's what I
allegation.
need John to say. I don't have any witnesses, I don't have any evidence, we don't know of
You know,
them ever doing anything violent. All we know of is water. You need to fill that in for me, John.
Well, and the other thing at this point, how old the case is, the chances of us proving any of that abuse is not gonna happen.
There was some abuse?
There was allegations, there was nothing, some of the kids basically complained about the staff being rough with them, but there was nobody got arrested for that, nobody got interviewed for that, so there's basically no proof of that, just allegations.
The cops didn't go out and interview victims and prepare reports for your offices?
No, they did, but I mean, there was not, Mr. Gibson's client and her husband were the only people that got arrested, regardless of what the allegations were.
The cops went out and interviewed the kids, prepared reports, submitted them to your office, and said, these kids were beaten by staff, or whatever the allegation was. And then your staff, now 2 or 3 years later, can't find the kids, and you're just submitting it to me.
Well, because there was no complaints filed against anybody that was doing alleged physical abuse.
because your office investigated it and decided there was not any alleged physical abuse,
Judge, I think,
Not that we could prove.
not that you could prove.
and also it's that my clients were accused of letting their staff be too heavy-handed with the kids. Now, it's not even rising to the level of abuse, just the kids didn't like being told what to do, and then, so when the cops came to take their, interview them and get statements, the children just went off and created their own fact patterns, and none of them were consistent. That was
How do you know that?
reading the GE reports.
You didn't do a prelim with all the kids, did you?
No.
Anything else, John?
No, I don't.
All right. I'm gonna ask you to have a seat in the audience while I contemplate this for a minute. I'm gonna do some other cases, two things at once, to announce to the women of the community that they found a man that can do two things at once. Because I'm gonna consider, yes, thank you. I'm gonna consider this a argument and then do some other cases at the same time. You'll think it's impressive until you hear what I'm gonna announce. Then you'll say, I'm not so impressed. This is case number 210097, State versus Patricia Shelby. How do you pronounce this?
Chapuis.
Chapuis?
Chapuis.
Like it's French?
Swiss French, yes.
Chapuis.
Yes.
Okay. I'm too nervous and uncomfortable going forward with this plea at this time because of the criminal complaint and the information stating 50 or so charges for different kids and allegations of abuse and neglect and so forth. So I need the state to file for me a pleading stating why the Sandy case should be followed and we should accept this plea and the facts and circumstances behind it. If the state's gonna set forth that they can't locate any of the 50 witnesses, they're not aware of any physical abuse, they can't prove the case and so forth in court, put those facts on a pleading for me, and then Tom, 2 weeks later, you can reply to it or answer it, whatever. And then we'll meet back here after I've had a chance to look at the facts and circumstances. We'll meet back here on December 6th at 0900. And that'll give me a chance to make a more informed decision and not be so nervous that I'm letting somebody who's accused of 50 counts of abusing kids walk off with a couple of wobblers or gross misdemeanors or something. I'm not saying it's wrong, it may be the right thing to do, I just don't know and I'm too nervous to make that uninformed decision. Any questions or comments for me?
What was the date again?
December 6th, that's 4 weeks from now.
When do you want my pleading room?
2 weeks. Tom will follow a week later. That'll be a week to read it. And like I said, I'm not saying you guys are wrong, you may be right, and we should let her do 2 gross misdemeanors. I just don't know, that's the problem. So we'll decide on December 6th. All right, we'll see you then, December 6th, 0900.